Hi, welcome to Mondays with Melissa. Today we're going to talk about probate versus estate administration. So when somebody dies and they have a will, their will is going to be submitted to probate. So that is a petition that is prepared and filed with the court along with the will. And that will dictates where your assets go when you pass away. So for example, it could say that your house goes to a specific individual, or it could say that your house gets split between certain people. You can dictate whether or not you want your house to be sold, and then the proceeds given out. Or you can even dictate if somebody can live in the house for a certain amount of time before it gets sold. So all of this gets put into the last will and testament, and then when you pass away, it's admitted to the court for probate, and your executor, who you name in your will, is the person who's going to handle making sure that everything gets distributed the way that you have stated in your document. But many times people in New York State, they'll die without a will. And when you die without a will, your estate needs to be administered. We call that estate administration. And instead of an executor, you're going to have an administrator. And basically what that means is we're submitting to the court advising that this person has passed away, but that they do not have a will. They did not leave a last will and testament. And in that case, the first $50,000 of estate assets would pass to the individual spouse plus 1/2 of the balance of the estate, and the other half of the balance of the estate would actually go to children equally. Now, if a person is not married and they have children and they die without a will, everything will go to the children equally. And if they are not married and they don't have any children, then the assets will continue through the family, starting with parents actually, and then siblings, nieces, and nephews. It's a very common piece of misinformation that in New York State, if you pass away without a will, that your spouse gets everything. Now, also keep in mind that we're just talking about the actual estate itself. There are assets that pass outside of an estate, and those are assets that have a named beneficiary, a joint account holder, or those assets that may be put into a trust and the trust has the beneficiaries listed. Those assets will pass to whomever they're supposed to. In other words, to whomever the beneficiary is, to whomever the joint account holder is. But assets that are in your name alone when you pass away, if you don't have a will, they're going to be given out according to the New York State Laws of Intestacy, which is through estate administration. So it's really important, if you have thoughts and ideas about who you want to leave your estate to, that you sit down with an attorney and you put those thoughts and those ideas in writing in a last will and testament. Because otherwise things may not pass the way that you want them to or the way that you think they're going to. So always a good idea to sit down and really flesh that out with an attorney. Please put any questions into the comments. We'll see you next week.